So are we good to start?
Yes.
Yes. Thank you. So, good evening to everyone present here. I am Aryan Gupta, senior writer at the Just Corpus Law Journal and the host of the today's session. I, on behalf of the whole Just Corpus team, welcome you all in the today's session on the journey of unnatural offences in India, hosted by Just Corpus. Before we delve into today's discussion, let me provide a brief introduction of Just Corpus and the eminent guest speaker of the day. Just Corpus is a body of legal professionals who have come together to bring various aspects and chains of law under a single umbrella. Just Corpus, an edtech platform set up in 2020, has a wide reach of 600,000 clicks per month on an average basis on our website. The inspiration was derived from the ever-growing need for law students. Just Corpus is also incorporated an interdisciplinary journal and a multidisciplinary journal as its subsidiaries named as the Just Corpus Law Journal and the International Journal of Law Research and Education in Social Sciences. Now turning our attention to today's focal point. We are privileged to have Mr. Sangram Jadhav as our esteemed guest speaker for today. Mr. Jadhav is currently serving as an assistant professor at the Government Law College Mumbai. Prior to GLC Mumbai, he worked as an assistant professor at the Maharashtra National University Mumbai, and as an alumnus of the GLC Mumbai, he graduated in 2020 and later completed his LL.M from the NLU Delhi. In the UGC NET JRF examination of 2020, he achieved the highest score in the country in the law subject. He's presently pursuing his Ph.D. at the ILS Law College Pune. So, without any further delay, sir, we now hand over the mic to you to hear your opinions on this topic at hand.
Thank you. Thank you, Aryan. So, as we all know, today's topic for this discourse is journey of unnatural offenses in India, right? So, we will start from the very inception, right? And first, we will try to understand what is so-called unnatural intercourse, right? So, let me tell you more about this topic. There is one more topic which is related to this topic, and I think it is apt to discuss it at the very inception. And that topic is sexual orientation. There are two things. First is sexual orientation and sexual identity. Right? Let me tell you that today we will be discussing about sexual orientation and not sexual identity. Okay? Sexual identity means recognition of this community as a third gender. We will be discussing about sexual orientation. Sexual orientation means attraction of a person, sexual attraction of a person towards other person. It may be male, it may be female, right? So we will be discussing about sexual orientation. Now we will start from the very ancient period, that is period before Britishers came to India, because uh, let me tell you that the surprising fact is that this was not an offense before the Britishers came to India. Okay, it was made a criminal offense, unnatural intercourse. It was made a criminal offense the moment Britishers came. So first we will discuss the situation, social political condition of India before the Britishers came, and then how it was made a crime and afterwards. So first thing is that what is unnatural intercourse? What is so-called unnatural intercourse? Unnatural intercourse means if any intercourse, if it is taking place for the purpose of getting pleasure, if it is taking place for the purpose, not for the purpose of procreation, not for the purpose of reproduction, then such a intercourse is considered as unnatural intercourse. Intercourse which is against the order of nature. Now, if we start from the very ancient period, you can see there are references. So before Britishers came, we all know we did not have a codified law to govern the society, right? And there were various sources, and sources like smritis, shrutis, uh, commentaries, so mitakshara, daya bhaga, customs and practices we had. So if you refer to those sources, you will understand that 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 these community, it was respected, it was recognized, it was acknowledged. But whether the intercourse, whether the same-sex intercourse was permitted or not, that is a disputable, contentious issue. So there are references where third gender people, they have been socially accepted, like from which we can infer that they had been socially accepted as a community. But whether the intercourse was permitted or not, that was something, a disputable question. So like further, if you refer to some sources like Kama Sutra, right? Kama Sutra recognizes homosexual intercourse, right? If you see the temple of Konark, it has the scriptures which depicts homosexuality. But on the other hand, if you refer to other sources like Narad Smriti, Manu Smriti, right? It banned homosexuality. It did not permit same-sex intercourse as such. But Kama Sutra, it recognizes the homosexual uh, as a partner, as a sexual partner in a limited way. So if you refer to the Kama Sutra, it says that they can find pleasure by being on receiving end of the oral sex. So it recognizes them as a sexual partner in a limited sense, because technically speaking, they cannot be a sexual partner in absolute sense, right? So, but again, uh, it was contentious to say that it was permitted, but I can tell you one thing with certitude, that for sure it was not an offense. Same-sex intercourse was not an offense before the Britishers came. Then we need to understand the situation of UK as well. As I said, it was made a crime the moment Britishers came. So we need to understand the situation, the political situation, social situation of UK at that time as well. So please understand this, that in UK at that time, unnatural intercourse or same-sex intercourse was considered as a highly sin. It was not acceptable in the society in UK. There is a belief in Christianity that intercourse, a sexual intercourse, can take place only for the purpose of production, only for the purpose of reproduction, procreation, only for the purpose of conceiving, right? It cannot take place for the purpose of obtaining pleasure, and that is why it was considered as a highly seen in UK at that time, not now, right? But at that time, religious courts, they used to handle those matters, and you won't believe that at that time, death penalty was the prescribed punishment for this wrong in UK. So when Britishers came to India, they were shocked. They were shocked because member of this community, it was receiving acknowledgement, right? It was getting acknowledged, it was receiving appreciation in India. So they were shocked, and the moment Britishers came, they enacted a law, and that is why the moment Britishers came, the position of this community, it got started declining. Otherwise, there are various references where this member of this community, it got acknowledged. For example, if you refer to Mahabharata, we all know in Kurukshetra war, uh, Bhishma Pitama, he was killed by a transgender called Shrikhandani, right? There are various other references when even this Lord Krishna, he took the form of a transgender called Mohini, right? So there are other various references. The member of this community, it got acknowledged, it got appreciated, regarded by the community. However, when the Britishers came, they were shocked looking at the situation and status of this member of this community in India, and that is why they enacted majorly two laws. First is Criminal Tribes Act 1871, and second is our Section 377 of Indian Penal Code, which prescribed punishment for unnatural offences. So, in UK at that time, during that time, uh, as I said, religious courts, they used to handle this matter. And when King Henry VII of England, he broke away with the church due to certain issues. The law in UK, it got codified, and then they enacted this law of 1953, 1930, 1533, and the act called it a horrible offense. So please understand this. It was so serious at that time in UK. This wrong was so serious that for this wrong, for this wrong, 404 people, they got, they were sentenced to death. They got death sentence for this wrong. And you won't believe, 56% in UK were executed for this wrong. So on my screen, it is written that James Pratt and John Smith, they were the last one to be executed in Britain for this wrong. Now, as I said, the moment Britishers came, they were shocked, and that is why they enacted the law, right? Now, we will discuss how that law, how this section 377 particularly, how it has got enacted. Uh, so we all know that first Britishers came to India as a trader, right? But the moment they got to know about the social political condition of the country, they started fighting with Indian rulers. And we all know the history that after the War of Plassey in 1757, they got Diwani rights, and then they tried to regulate the subject matter of Indian society. So we all know in 1933, Lord Macaulay was appointed as a chairman of the Law Commission, and he headed the committee, and the committee submitted the draft penal code, and it consisted of 488 clauses, right? And then it got revised by various other members of the committee and other judges of the High Court and Supreme Court at that time. Then finally, though the mutiny took place, we all know the famous mutiny took place in 1857, but the code was passed in October 1860 and came into effect on 1st January 1862. Now, let me tell you let's discuss this section 377, right? So, these are the two clauses. As I said, initially it was drafted by Lord Macaulay, and this is how it got drafted. So these are the two clauses, which is apparent on your screen. So this is clause number 361 and clause number 362, right? So clause number 361 and 362, it used to deal with unnatural offense. And I request all of you to read these two clauses. See the difference. If you read this clause number 361, it deals with unnatural offense, right? If unnatural intercourse against the order of the nature, if it takes place without consent, right? Without consent, then we have clause number 362 that deals with it without consent, and 361 is with consent, right? And if you see the difference is for 361, the punishment is lesser. So if the unnatural intercourse, if it is taking place with the consent, then the prescribed punishment is lesser, right? Whereas in 362, if it is without consent, the punishment is high. Now, this is how it got drafted by Lord Macaulay, right? So, even at that time, let me tell you, at that time when it was so unacceptable in UK, Lord Macaulay, he was wise enough to recognize lesser sentence for a crime of unnatural lust if performed with consent, right? So we can infer how unacceptable it was in UK during that time. If you read his statement, this is his statement. So the moment he submitted the draft to the Lordship for the recognition, he said these clauses 361, 362 deal with a very unpleasant type of crime, and it is better not to talk about it too much. right? He said, we have written two clauses for such offense and left them for the decision of the Lordship in the Council without adding any comment. We did not want to include anything in the main text or in the notes that might start a public discussion on a disturbing topic. Lord Macaulay called this offense as a disturbing topic, and he was not ready to talk about it. He said such a discussion would harm the public morals. So, from this statement only, we can infer how unacceptable it was for the Britishers, how unacceptable same-sex intercourse was for the Britishers. So, but though it was so unacceptable, he was wise enough to recognize less sentence for the crime if performed with consent. Now, it got drafted in this way by Lord Macaulay, but finally it took form in this way, which is apparent on your screen. This is the text of section 377. And if you see, if you read the text, whoever voluntarily has a carnal intercourse against the order of nature of any with any man, women, animal shall be punished with the imprisonment for life or imprisonment of either description for a term which makes into 10 years and fine. And there is an explanation that penetration is sufficient to constitute the carnal intercourse necessary for the offense described in above clause or above in this section. So if you see this text of 377, you can see that this law, section 377, the original text of 3 section, the final text of the 377, it does not differentiate between a consensual unnatural intercourse and non-consensual unnatural intercourse. Now, it was drafted in this way, it got the final shape in this way. Now, the exactly what went wrong at that time, we do not have conclusive evidence for that. It is not exactly clear at what point after 1837, this section 377, it took its final form in this way. Now, with respect to this section 377, let me tell you about uh, post-independence. So, as I said, the moment Britishers came, they enacted two laws to discourage the practice of recognizing the members of this community. So, one is Criminal Tribes Act 1871, and second is this section of 377. That is unnatural, so-called unnatural offense. Now, after independence, Nehru government in 1951, they repealed that law, Criminal Tribes Act 1871, but they did not touch this section 377. And the legacy of 377, it continued. So this section, it has been in use for 150 years and has very few changes made to it. So we have two law commission report as far as this wrong is concerned. First is 42nd Law Commission submitted in 1971, and that law commission did not suggest any change in this provision. And second law commission is 172nd Law Commission report submitted by Justice Jeevan Reddy, uh, and that committee recommended of removing this section 377 and making section 375, that is rape, as a gender neutral offense. We will come to this point later on. Actually, this report, the later report, the second law commission report, 172 law commission report, it played a very important role uh, in the judgment of Navtej Singh Johar, where the Supreme Court read down this provision. So while decriminalizing this provision, the 172 report, law commission report, it played a very, very crucial role, very important role. We will come to that point later on. Now, before I tell you how it got decriminalized in India, let me tell you more about it and how it got decriminalized in UK. Because as I said, it is the Britishers who introduced this wrong in India, right? It was made crime after the Britishers came. So that is why I need to tell you how it got decriminalized. in UK first. So in UK, as far as this wrong is concerned, as I said, it was highly unacceptable in UK at that time. It is based on a Christianity rule and custom that an intercourse can take place only for the purpose of uh, procreation or reproduction. So till 1861, death penalty was the prescribed punishment for this wrong in UK. In 1861, death penalty was removed as a punishment, and things got changed. So there are various famous trials as far as this wrong is concerned. Let me tell you one to two trials. So one trial is related to Oscar Wilde. So Oscar Wilde, he was a very famous author in UK at that time, and he published a poem on the title "Love That Dare Not Speak." Okay, it is a story regarding how a older man has fallen in love with a younger male person. The moment it got published, he was arrested. He was arrested on a suspicion that he is also a gay. And later on the trial, it continued. Apart from Oscar Wilde, so actually this poem, it got quoted by Justice Rohinton Nariman while decriminalizing this sexual homosexual relationship in Navtej Singh Johar case in 2019. There is one more trial regarding Alan Turing. Actually, he was that genius who helped the UK government to defeat the Nazis in World War II. But even he was arrested for this wrong. As I said, uh, that it was highly unacceptable. It was considered a sin in UK. But after World War II, majorly, uh, things things began to change in UK. And to understand the changing scenario, to understand the changing perspective of the people, the government appointed a committee, and the job of the committee was to look into the law about homosexuality and how the people found guilty of such act were treated by the courts. While submitting report, the committee suggested that the committee discussed the arguments for and against this law. And in para 61, the committee suggested that now time has come where we should give importance to individual freedom. The committee said that uh, this is something, homosexual relationship or same-sex intercourse, unnatural intercourse, so-called, it is something which is taking place in a private place of an individual, and it does not harm the society per se. That is why the committee said time has come where we should give importance to individual freedom. And further, the committee suggested that law should not intervene. Law should not intervene, and it should respect rather a person's right to make their own choices about the private moral matters. So the committee suggested that law cannot govern everything. So there are certain things which are left to the people. So they should have the right to make proper choice, and sexual orientation is one of them. Finally, in 1967, after taking into account the recommendation of this committee, in UK, British Parliament enacted a law and they decriminalize homosexual relationship in UK. Now, see how shocking it is. In India, it was not a crime before the Britishers came. It was made a criminal offense after the Britishers came. But we decriminalize it in 2019. But in UK, it was decriminalized in 1967. Justice D.Y. Chandrachud, while reading down this provision in Navtej Singh Johar case, he referred to this fact and he said, this shows how strongly a past can hold on the present. Now, before I will tell you that how it got decriminalized in India. So, as we all know, we have three cases. First is NAS Foundation versus NCLT Delhi. Second is Suresh Kumar Kaushal versus NAS Foundation. And third is Navtesh Singh Johar versus Union of India. We have these three cases. And finally, it got decriminalized by the Honorable Supreme Court in 2019. Before we can discuss that fact, on what grounds uh, it has been decriminalized. Uh, Before that, let me tell you about there is one expression called carnal intercourse. So, if you read this section 377 again, it uses the expression carnal intercourse. Right? Please pay attention that it is not sexual intercourse; it is carnal intercourse. Right? And now, how this carnal intercourse is different from sexual intercourse? Right? That we need to understand. So, what is carnal intercourse? Let me tell you. We all know the definition of rape, right? The definition of rape uses the expression sexual intercourse, and 377 uses the expression carnal intercourse. So, first, let me tell you sexual intercourse can be divided into two categories. Okay. First is traditional form of penetration, and second is modern form of penetration. Okay. Traditional form of penetration means intercourse taking place for the purpose of reproduction. All right. And in that case, penetration is necessary, right? To constitute that wrong, penetration is necessary. And that is rape. If you see the definition of rape now, it is different. All right. Please understand, before 2000 criminal law amendment, the definition of rape was different. The definition of rape was if a man has a sexual intercourse with a woman without her consent, and that offense is rape. That was the definition. And in that case, penetration was a prerequisite to initiate prosecution for the offense of rape, right? However, we all know Nirbhaya incident took place and the law got changed. Parliament introduced Criminal Law Amendment 2013. And now the status is that if you read this section 63 of BNS, Bharatiya Nyaya Sanhita, or section 375 of Indian Penal Code, which defines rape, the definition is very wide, right? It is not narrow like before we had it, 2013 wala criminal law amendment, right? Now the definition is very wide. But before 2013, the definition used to cover only and only traditional form of penetration, traditional penetration, right? So before 2013, if suppose, so what was the definition? If a man was having an intercourse with a female, sexual intercourse, wherein in which penetration is necessary, without her consent, then that is rape, right? But suppose if a man was having an intercourse with another man, right? Or man was having an intercourse with women without consent, but penetration did not take place, right? If it was a modern form of sexual intercourse, that is intercourse for the purpose of getting pleasure, then it did not fall under the definition of rape, right? So which section used to deal with it? It was section 377, which used to deal with it. That is unnatural offenses, right? And that was carnal intercourse. Are you getting me? See, what is carnal intercourse? Carnal intercourse means bodily touch. Such a bodily touch, which is in which penetration may be there, may not be there. But such a penetration is not the traditional form penetration is not there. That is such an intercourse is not taking for the purpose of reproduction. Such an intercourse is taking place for the purpose of getting pleasure, right? It is called modern form penetration. It this section used to deal with it. Are you getting me? Right? So please understand the concept of carnal intercourse. So it so if you read this case, it is of state of Kerala. where the court said the accused could still be punished under Section 377, even if there was no penetration into the vagina. That is traditional form penetration, right? So it used to deal with modern form penetration. However, after the 2013 amendment, now if you read the definition of rape, Section 63 BNS, the definition, the Parliament has widened the definition, right? Now it covers both traditional as well as modern form penetration. That is intercourse taking for the purpose of procreation, as well as intercourse which is not taking place for the purpose of procreation, but for taking place for the purpose of getting pleasure. Now I will tell you the things, right? I will tell you the factors uh, on the basis of which the Honorable Supreme Court in Navtej Singh Johar case, they decided to read down this section. So the first thing is 172 Law Commission report. I told you that the recommendation of this committee, it played a very, very important role while reading down this section 377. As I said, before 2013 criminal law amendment, the definition of rape was restricted to only traditional form of intercourse, where penetration was a necessary precondition to initiate the prosecution, right? And see, that change was made due to the recommendation of this committee, that is 172 Law Commission report of submitted by Justice Jeevan Reddy, and this committee suggested that we should why we should have the definition of rape in a wider manner, right? And it should be made gender neutral, okay? And we should remove section 377 from IPC. That is what the committee said, okay? It was one. Now Parliament adopted the recommendation partly, okay? Parliament Parliament they widened the scope of section 375 as suggested by the committee, but they did not make it gender neutral offense, right? Rape is a gender bias offense. Only a man can commit rape, right? It can be committed over a women only, right? A female cannot commit rape over a man, because that is a uh, gender bias section right now. So the Parliament did not accept the recommendation of this committee to make it a gender neutral, right? And the Parliament did not accept it. Parliament did not remove Section 377 from IPC. And please understand, the legal implication of this thing is it created legal contradiction between 375 and 377. Please understand this. As I said, unnatural intercourse, uh, if it was taking place before 2013, then 377 was there to deal with it, right? But now after 2013 amendment, the definition of rape is sufficient to cover both traditional intercourse where penetration is necessary and modern form of penetration or intercourse. So that is why if you read 375, what is 375 right now? What is section 363 of BNS right now? If man if man is having an intercourse, right, of following nature, so there are four types: with women without consent, right, and that includes unnatural intercourse, that is anal sex. If it is without consent, then only it is rape, and if it is with consent, then that is not rape. Are you getting me, right? Whereas 370 says that even if a man is having intercourse with a female, that is anal sex, against order of nature, even if it is with consent, then that should be crime. So it created legal contradiction. 375 said it is not crime. 377 says it is a crime. So it created legal contradiction between 375 and 377. The second legal implication of this fact is that, see, after the criminal law amendment of 2013, the rule says that if a man is having a intercourse, even if it is against the order of nature with a female, right, with consent, and it is not right, it is not a crime. But 377 that if a man is having intercourse with a man, even though with consent, that should be a crime. So court said this is discriminatory, this is arbitrary, right? We all know arbitrariness, the doctrine of arbitrariness. Court said this is arbitrary, this is against the rule laid down in E.V. Royappa case, that when there is a arbitrariness, there cannot be equality. That is why the court said it is a violation of equality, right? So this is the first and most important ground uh, on the basis of which the Honorable Supreme Court of India in Navtej Singh Johar case laid down this section 377. Now the second factor which the court uh, did take into account, the second factor is morality. As I said, court said this section is based on a logic. It is based on a custom of a Christianity, which is not in force in UK right now, right? But so UK decriminalized homosexuality in 1967, but we still continue this practice, right? Court said, what should prevail, popular morality or constitutional morality? So let me tell you, when the first, like, uh, when Delhi High Court decriminalized homosexual relationship in Nas Foundation case, it got challenged by Suresh Kumar Kaushal. And do you know who is Suresh Kumar Kaushal? He's an astrologer, right? He said, uh, making it not making it a crime is against the popular morality, right? Even he filed an intervention in Navtej Singh Johar case, and that at that time court said, what should prevail? What should prevail? Which type of morality should prevail? Public morality should prevail or constitutional morality should prevail? So the court has made it clear that only and only constitutional morality shall prevail. Now, what is constitutional morality? Court said constitutional morality means respect for the values of the constitution. And what are the values of the constitution? Freedom, liberty of individual, equality is the value of the constitution, and we should respect them. And that is why court said this is the constitutional morality, and it should prevail over any form of popular morality. Now, I will not go into the detail of this constitutional morality. The court discuss about conduct-based constitutional morality and value-based constitutional morality, right? Uh, then the next factor which the court uh, did take into account is that sex and sexual orientation. As I said at the outset, I said we are discussing about sexual orientation, right? We are not discussing about sexual identity, am I right? For sexual identity, we have the judgment of Nalsa, but we are discussing about sexual orientation. So there was an argument that sexual orientation is not part of a sex. So as we all know, Article 14 deals with right to equality. 15 deals with no discrimination on the basis of certain grounds. Please understand this. What is the connection between 14 and 15? The connection between 14 and 15 is that 14 says that what is permissible, reasonable classification is permissible, right? And what is not permissible, class legislation is not permissible, right? So, what is reasonable classification? The answer has been given by 15 and 16. 15 says that if there's a discrimination taking place on the ground of religion, race, place of birth, sex, or any one of them, then it cannot be a reasonable classification, right? So the argument is that if there is a discrimination on the basis of sexual orientation, it is a discrimination on the ground of sex. That is why it is not a reasonable classification, right? The petitioner argued the same, but the respondent said their sexual orientation is different thing and the expression sex is a different thing. However, the honorable court, uh, refuses the argument, and court said sexual orientation is a part of the expression sex. Okay, for the purpose of Article 15, and that is why court said the legal contradiction between 377 and 375 is a violation of Article 15. That is not reasonable classification because that is a discrimination on the basis of sexual orientation, and ultimately that is a discrimination on the basis of the expression sex. Then the next round, which the Honorable Supreme Court will take into account, is uh, rule of presumption of constitutionality. So, as I think we all know, most of you may be aware of this fact that there is a presumption while interpreting a law. There is a presumption that law made by Parliament is constitutionally valid, and if you are proving or if you are claiming the other side, the contrary thing, then the burden lies on you to prove the contrary thing, right? So, the if you read the judgment of Suresh Kumar Kaushal judgment, actually it begins by assuming that the law is constitutionally valid, that is IPC 377. However, uh, the Naute Singh Johar case, so we all know Nas Foundation case, it got reversed by Honorable Supreme Court in Suresh Kumar Kaushal. Uh, and finally, uh, when the Suresh Kumar Kaushal got challenged in Naute Singh Johar case, Supreme Court read down the provisions. The five judges of the Supreme Court, that is Justice A.M. Khandvilkar, Justice Deepak Mishra, then Chief Justice of India, Justice Rohinton Nariman, Justice D.Y. Chandrachud, and Justice Indu Malhotra, by a 5-0 majority, they read down the this section 377, that is Consensual Homosexual Act. The Supreme Court in Naute Singh Johar case said, yes, there is a rule of presumption regarding the constitutionality of any legislation, but such a rule, such a rule of presumption is not applicable with respect to pre-constitutional law. The court said, with respect to pre-constitutional law, we this rule of presumption is not applicable, right? Because with respect to pre-constitutional law, please understand this. Pre-constitutional law, there is a one provision in the Constitution, that is 372, which says that a pre-constitutional law, that is law made before the Constitution came, will remain valid if it does not violate any provision of the Constitution. And the president has a power to make the changes, right, into the in that law if it violates any part of the Constitution. Court said just because the president has not made any change, it does not mean that the law is constitutional. Okay, the law is automatically constitutional. Please understand this. So I will tell you the rationale. The rationale behind this rule is that we all elect our representatives, and in parliament, the law is made by the parliament. That is, the law is made by the representatives, our representatives. That is, a member of the parliament, MPs. So there is a presumption that MP, he knows our the need of the people, and that is why there is a presumption that parliament will not make a law which will contravene the constitution, the mother of all the laws. That is why there is a presumption. But court said this presumption is not applicable, will not be applicable to a colonial legislation or any pre-constitutional legislation, right? Because such a law was made by the foreign entity, was not made by the parliament. So basically, these are the uh, certain factors which the Honorable Supreme Court did take into account in noticing your case while reading down this section 377 of the IPC. Now, let me tell you about the personal opinion of the judges. So, Dr. D.Y. Chandrachud, while reading down the provision, said that now we cannot undo the past injustices, but the least thing that we can do is that now we can extend our helping hand to this community. And Justice D.Y. Chandrachud said, we need to move. We need to move from denial to freedom. He said, we need to move from denial to freedom as the democracy is coming from ashes of greed. Whereas Justice Rohinton Nariman, he he quoted Oscar Wilde's that poem, "Love That Dare Not Speak." Uh, Justice Indu Malhotra, she said, "History owes apology to this community for these past injustices. Justice Khandilkar and Justice Deepak Mishra, they quoted one poem uh, that is a German thinker, which says that I am what I am, so take me as I am. And on the basis of these grounds, after considering other factors, the Honorable Supreme Court gave its landmark judgment and decriminalized consensual homosexual relationship in India in Navtesh Singh Johar versus Union of India 2019. Now, please understand, after this judgment, see, this community has a long battle to fight for. After this judgment, it was not a crime. Now, it is not a crime. Homosexuality is not a crime. But the legal rights of this member of this committee has not been recognized yet. So in 2013, in Supriya versus Son of India case, the Supreme Court refuses to acknowledge same-sex marriage, right? And the court said it is supposed to be done by the parliament, right? So these are the things they have a long battle to fight for, right? And now, as far as this wrong is concerned, because in our discourse, today's topic is restricted to only this unnatural offense. So we all know that it got decriminalized in 2019, and in 2023 when a BNS replaced Indian Penal Code. In BNS, this section 377 of IPC has been omitted. Now we do not have this unnatural offense, but there is one problem with this BNS as well, right? See, what is the problem? The problem is section 63, which defines rape, is wide enough to cover, as I said, traditional intercourse as well as modern intercourse. That is unnatural intercourse, right? But rape is a gender biased section even today. It is not gender neutral section. Are you getting me, right? See, so suppose let's take a situation. If a man is having an intercourse with another man, right, without consent, suppose he's having an intercourse, unnatural intercourse, anal sex with a man without consent, it should be crime. Am I right? But it is not a crime. There is no law to govern the situation because now we do not have this section 377 in BNS. And as far as offense of rape is concerned, it is not applicable to male person, right? The victim in rape can be only female person. That is not, rape is not a gender neutral provision. It is a gender bias provision, right? So that is the issue. Hopefully, the parliament will bring the necessary change in the BNS. Uh, now, so that's all for this topic. That is the journey of this unnatural offense uh, in India. Now, let me tell you that this law got decriminalized in 2019, and now to govern the rights of this member of this community, Parliament enacted a law called Transgender Person Protection of Rights Act of 19. But the thing is that even that law is insufficient to bring social change. And I remember Dr. P.R. Ambedkar words. So in a constitutional assembly, a question was asked to him that why we are having such a lengthy constitution, right? UK don't have a written constitution only. So why we are having such a lengthy constitution in India? He said, the people, we we are yet to learn constitutional morality. He said in UK, the idea of constitutional morality has been developed, right? And that is why they do not need a written constitution. That is why they do not need lengthy constitution. But in our India, we are yet to learn constitutional morality. And he said, the moment we will be able to understand, we will develop the concept of constitutional morality among ourselves, we won't require a law to bring social change. We won't require a judgment of the Supreme Court to bring social change. So, uh, while concluding it, I would say that it is for all of us that we should be a vigilant citizen and we should develop constitutional morality, that is respect for the values of the constitution. And From our end, we should ensure that member of this community shall not face any form of discrimination. I would conclude by saying two lines. I still remember those lines. I think that is apt to describe the inclusive nature of our society. Uh, these lines are, जिसका ताज हिमालय हो, जिसका ताज हिमालय हो, जहाँ गंगा बहती हो, जहाँ अनेकता में ही एकता हो, वो भारत मेरा है, वो भारत मेरा है. I think that is sufficient to describe the tolerant nature of our society, and constitutional morality requires us to take progressive steps in order to recognize the rights of members of this community. So, while concluding it, I thank Just Corpus for having me today with all of you. Thank you.
Uh, Thank you so much, sir. Thank you so much for a wonderful session. You beautifully explained the entire history of unnatural offences in India, and while linking it to constitutional and not just constitutional, you linking it to constitutionalism, the spirit of constitutional, which I'm pretty sure the participants found it very interesting. And we have also received a few questions, so I would like to proceed with those if that's all right.
Please, please.
Thank you so much, sir. So, sir, the first question we have is, how does the legal position of India in regards to unnatural offences compare with the other countries?
I mean, how does the
How does the position of India currently regarding unnatural offences compare to foreign jurisdictions, foreign countries?
foreign countries? Right. So this, as
Yes,
far
sir.
as same-sex intercourse is concerned, as I said, it is not a crime in UK. It is not a crime in USA as well. Okay. In USA, it got decriminalized in 2001. So consensual homosexual act is not a crime in UK, in USA, and other countries as well. So you won't believe, uh, Nepal. Okay, Nepal decriminalized this offense in 2005. Okay, we did it in 2019. So as far as foreign countries are concerned, in most of the countries, it is not a crime. Okay, let me tell you, in Pakistan also, it is not a crime.
Thank you so much, sir. So, next question we have is, how can the state of, as you also explained, how can the state of the rape of an adult male be addressed in our current laws? Because the rape of a female is being covered under the BNS, and the rape of
Right,
a minor child, irrespective of the gender, is covered under POCSO.
right,
So, where does the adult male stand and how it can be addressed?
right. So as I said, that is the lacuna we have in BNS, because as you rightly said, in section 63 of BNS, the definition of rape is gender bias. Only a man can commit rape over a female person, right? So one thing can be done. Parliament should introduce a new offense, because see, the definition for rape is very high, right? And if we make it gender neutral, then the counter argument from the government is that the punishment is very high and it can be misused by male person as well. Suppose if a female person has charged a male person for the offense of rape, if it is gender neutral section, the female person will also file a FIR against a female person for the offense of rape. And there are chances of misuse. That is what the government said. That is why one thing can be done, that we should introduce a new offense. Okay. We should introduce again unnatural offense, but it should not cover consensual homosexual act. It should only cover non-consensual homosexual act, and the punishment for the same should be proportionate to the seriousness of crime. That is, it should be 3 year, 4 year, or 5.
Thank you, sir. So another question we have is, how was this section 377 interpreted in the context of necrophilia, that is the rape of a dead body? And now that this section has been removed, is there another lacuna present in, in the cases of necrophilia?
With respect to dead body,
Yes, sir. Like,
did you?
was this section ever invoked when there
Ah,
were cases of rapes of a dead body?
Right, right. So actually, with respect to a dead body, uh, this provision actually it did not like it had not been invoked that, but it could have been invoked. Okay, because as I said, uh, see the section. This law is about carnal intercourse. Getting me? That is not about sexual intercourse. The penetration is a precondition, right? So with a dead body, carnal intercourse may take place. So it can be used, right? Though I did not, I'm not in position to remember case law in which it got invoked by the court, but it can be invoked.
So, thank you so much, sir. So that was all from our side. In closing, we extend our heartfelt gratitude to you for accepting our invitation and delivering such an informative session. And
Thank you,
we trust that the audience would found it more interesting and knowledgeable. And we eagerly anticipate the opportunity to host you again. Thank you so much.
thank you, thank you so much.
Thank you.